A husband is accused of killing his wife in broad daylight just steps away from the elementary school where she worked. Their more than 20-year marriage ended in an instant. For days, he was nowhere to be found. Now, Candido Rubio Perez is in custody, charged with murder. I'm Kennedi Walker, and I'll walk you through the details. For this story, we go to Nashville, Tennessee. A couple's marriage ended not with divorce, but in tragedy. A husband is now accused of murdering his wife. Candido Rubio Perez and Niurka Alfonso Acevedo were reportedly married for 24 years. They built a life together. They raised a family. But according to Niurka's daughter, behind closed doors, things were far from picture perfect. Her daughter, Kiyomi Martinez Alfonso, told WZTV that her mother ended her relationship at the end of last year. She allegedly asked Rubio Perez to leave their home, but he did not take no for an answer. He wanted another chance, and she refused. Kiyomi says her mother was planning to file a restraining order, but she never got the chance. April 14th, 2025, a Monday morning, would be the last time anyone saw Niurka alive. She had just arrived at Chadwell Elementary School, where she worked as a contracted custodian, but she never made it inside. According to court documents obtained by WKRN, Niurka was on a video call with a friend as she pulled up to work. That friend reportedly heard her say, quote, "Please don't hurt me. We have a son together." The call suddenly ended. Just minutes later, neighbors near the school called 911. Police say Rubio Perez was allegedly waiting there outside of the school. They believe he ambushed her and stabbed her to death. It was a fellow employee who found her body. School hadn't started yet, so no students were present. A manhunt began almost immediately. Police released Rubio Perez's photo to the public and urged anyone with information to come forward. 3 days later, he was found outside a high-rise apartment complex near Nashville and taken into custody. He's now charged with criminal homicide. Niurka Alfonso Acevedo leaves behind 2 children, her eldest daughter and a young son she shared with Rubio Perez. That child is now left without a mother and potentially without a father, too. Kiyomi says her mother came to the United States from Cuba in 2013, chasing a better future. She was a permanent resident and had been working towards becoming a U.S. citizen. To her family, Niurka was more than a victim. She was a mother and a grandmother, someone they described as caring, wonderful, and deeply loved. And joining me to talk more about this is legal expert Anthony Asso. Anthony, thank you so much for coming on today. Let's just jump right in. The suspect was charged with criminal homicide. Could this case potentially be upgraded to first-degree murder?
Well, criminal homicide, in my opinion, whether or not it's first or second degree kind of depends on what state you're in. But based on what I'm seeing, absolutely. I mean, this in my mind qualifies as murder. You've got what looks to be some sort of intent beforehand and motive, and that's typically what you're looking for to file that kind of charge.
Does the fact that he allegedly waited for her outside of the school help prosecutors prove premeditation?
Absolutely. I think that's a key. I think from the defense perspective, they could say that he was formerly working there or was working there. And obviously, I haven't heard all the eyewitness accounts, but if they can establish that he was lying in wait, that's premeditation 101. And so that's a strong fact for the state in that case.
And explain more just to our viewers that don't understand, what is lying in wait?
So I just think lying in wait is sort of you're waiting there for someone, right? And so that's different than acting out of the spur of the moment or out of emotion. That is methodical. It's planned out. And oftentimes I think he takes into account knowing, and it was this case, for example, knowing where she's going to be at a certain time and utilizing that to complete some sort of plan. That's really strong fact. That is a really strong fact for premeditation.
If the victim was heard on a call, saying, "Please don't hurt me," could that be used as key evidence in court?
I think so. Some people might argue, oh, well, that falls under the hearsay exception. But in that instance, there's a lot of exceptions to the rule of hearsay. And so here, if she's shrieking, screaming, it could be considered what's called an excited utterance. And so I think that phone call or that friend's account of her yelling would certainly come in during a trial.
Now let's talk about the location of the crime. It happened on school property. Does that add any legal weight to the charges?
I don't think so. As far as aggravating the case, I mean, maybe they could file an additional charge for possession of a weapon on school grounds, but I think here the core of what they're going after is justification for Ms. Acevedo and the murder charge, most likely.
What's the likelihood that his defense team argues that this was a crime of passion versus premeditated murder?
It's hard to put a likelihood on it because I think from what I've read, they can go a couple of different routes. I mean, I don't know that there's clear eyewitness accounts putting him on the scene. I think that there's I've read that phone call, so it depends. The defense may decide to go the identity route, but if they can establish that he was there on scene, uh, I think it's likely. If not in the guilt innocence phase, certainly during punishment, you could see the defense arguing that he was acting out of passion.
And explain more about that. How could that argument even work that he was, you know, doing this out of passion?
Sure. So it's jurisdiction dependent. So not every state provides a sudden passion defense. So and I'll use Texas for example because that's where I've argued sudden passion. What happens is if you can establish that the person acted um, obviously suddenly from something that they've experienced that could give adequate cause, so it's got to be adequate cause, then in that instance, if the jury or the fact finder finds that you acted inside of passion, it reduces the punishment range from whatever degree the murder statute is to the next lowest degree. So in first degree to second degree, and it would minimize the punishment, the maximum amount of punishment you could get. So if the law prescribes that in Tennessee, there's a likelihood that they could argue that. But I think here that you might see an identity defense as to he wasn't there, it wasn't him, based on what I've read thus far.
And the victim's family says that she was in the process of trying to get a restraining order against the suspect before she died. What protections are actually available when someone wants a restraining order but hasn't filed one yet?
So if you haven't filed for a restraining order and there's no effective restraining order in place, then you're not going to have those protections. That's why it's important for victims or people that are seeing red flags to go forward and do that. Most of your local prosecuting offices have, especially in bigger cities, will have divisions set up to assist victims of domestic violence in filing those civil protective orders. You don't necessarily have to have a pending case in order for a protective order to be filed. And so, again, they've got the ability to seek help and try to get a protective order, but unless that's done, then there's not a lot of protection in that regard.
Would this case potentially fall under the domestic violence homicide category?
Absolutely. I mean, um, you've got a former. I think what I was seeing is that Miss Acevedo had ended the relationship with Mr. Perez, and he had tried to get his foot back in the door with her, and she refused. And I think one of the most common things we see and the most dangerous time for someone that is a victim of domestic violence is when they finally shut the door on their abuser, um, and walk away. And it's that ending that oftentimes is the most dangerous and violent time in a relationship that has domestic violence in it.
Police say that the suspect was allegedly on the run for days. When someone runs after a murder, does that usually help the prosecution's case?
Yes, and a lot of times in the penal code, or in case law, um, the state can actually argue for that for the jury to infer guilt from that. But it depends. Did they flee directly from the scene, or did the did he flee the scene and the cops got there too late and then they just couldn't find him? It sort of depends on the circumstances to say how important or how much weight that can be given in an actual trial.
So explain more about that. So
Sure.
what are you saying that explain
Well,
just the differences?
yeah, let me put it this way. So if if Perez commits the crime, is observed by witnesses, police make it, and he runs from the scene and then is apprehended shortly after, I think that's a very good instance where a jury could infer guilt from fleeing the scene. But he's if he commits the crime, leaves, and no one really has a good ID on him, and it takes a while for the investigation to develop, and then they create a suspect profile from him after the fact, it's hard to say, well, he fled or took flight from the scene. And so I just don't think it's as powerful as it would be in the first example.
Right. And if the suspect is convicted, is there
Yes.
any legal avenue for the victim's daughter to sue him civilly for emotional distress or wrongful death?
I think wrongful death would be the tort that she would want to go with. Um, I think the criminal arena really is where justice is sought, not to knock or take anything away from this practice of civil law, but I think that I don't imagine that Perez has an extremely deep pocket, because I think he was working as a custodian, and so I imagine that most of her justice will come through the criminal proceeding than it would through a civil proceeding. But that's not to say that she couldn't file a civil lawsuit um, and allege wrongful death. That's possible. I think that the bulk of this is going to be in the criminal court.
And could his defense claim any sort of mental health breakdown? And if so, like what would they have to prove exactly?
So to say, I think when you think of when you think of mental health as a true defense to whether you're guilty of a crime, it's got to come in the form of insanity, and they have to prove that at the time that the offense was committed, that Perez didn't recognize the consequences of his actions, which is a really steep hill to climb, especially like you had pointed out to earlier, flight from the scene, and that it took days to kind of figure out and apprehend him. I imagine that there's probably some messages some text messages regarding their relationship that the state could use to establish that he was sane and knew what he was doing, also to develop motive and intent. So I think I don't know that I see that as being the defense, but I do think mental health can be mitigating. And so even if it doesn't say, hey, I didn't, I'm still guilty of murder, it still could be relevant in the punishment phase of a trial to say, here's what the person was struggling with, which is why they committed the act.
And so with that, if that really happens, could he potentially get less time off of his sentence if that works?
So the way that the punishment range works, it's a large range, right? So there's a minimum and maximum. So that could be used in order to argue towards the minimum range of punishment, or less time than obviously a life sentence. And so to answer your question, yes, it could be used to sort of mitigate or lower the range, not lower the range, but lower the sentence amount.
And if you could just walk us through what's the next legal step after a charge of criminal homicide?
Yes. So in homicide, criminal homicide, I imagine the charge is going to be murder. Homicide is when a body goes to the medical examiner's office, homicide is just a description of the nature of death, right? I mean, there's criminal negligent homicide, which is a charge, but homicide itself isn't a crime. It's murder that's a crime. So after a charge is filed, then there's a long process. The state is going to have to provide the defense with all the evidence in their possession um, that is material to the case. There's going to be a lot of different hearings and settings, sometimes that aren't necessarily meaningful, some that are meaningful. And then there's plea negotiations between the state and the defense oftentimes. So that might not even be a trial. They could come to an agreement on a set number of years that both parties think is fair in light of the circumstances and resolve the case. But if it doesn't work out, then you would expect to see a trial at the end.
I was just going to say, how long does it take to usually, bring a case like this to trial? Are we talking about months or years here?
It depends a lot on the jurisdiction. I mean, if you've got a case in a very busy jurisdiction where, like Houston or Los Angeles, or it might be years before a case actually makes it to trial. Um, in a smaller county, I think it could go quicker. But anytime it's a murder charge, that's going to take some time. I mean, a year and a half at the very least, in my opinion, from my experience, I think, before this case would ever see trial, and it could be up to 3 or 4 years. So it just depends on the jurisdiction and the amount of evidence. A lot of things can happen between the filing of a charge and a trial setting.
And we just touched on this a little bit. Will he likely be offered a plea deal, or is this the type of case prosecutors usually take to trial if he is charged with murder?
Again, I think it's the lawyer's answer. I think it's jurisdiction specific, so there's no set rule. I think that they will offer him some sort of plea offer, and it makes sense to, in my opinion, because when there's a plea agreement, then the defendant waives their right to appeal, and so it creates finality in the proceeding. And especially in domestic violence cases, there's so much pain and emotion for the family surrounding. They're victims as well. And so there's a sense of security knowing that there's not going to be a long, drawn out appeal process that can sort of reopen that wound every couple of years that a filing is made in regard to the case. So I think there will be a plea offer here. Whether the defense accepts it or not, I don't know.
Yeah, right. We'll definitely have to wait and see for that. But, you brought up a good point about domestic violence. If we could just talk a little bit more about that. How common are these domestic violence homicides in the U.S.?
Unfortunately, very common. And I think they've been growing in number over the past 5 or 6 years. A lot of it had to do, I think, with COVID. But they're common. And I think that, when you see red flags and you see a relationship get more violent and then you throw in emotion, you've really removed logic from the situation. And so things can get dangerous quickly. And so it's important for people to keep their eyes out for red flags like that. I'm not in a victim's shoes, and there's a lot of barriers to disclosure. But it's very important that when you see those signs that you reach out to someone that you think could help.
And just in your experience, how do juries typically respond to cases involving domestic violence that turns deadly?
If they believe that the defendant committed murder and they believe that there was no justification in doing so, there's some very harsh sentences. But oftentimes, domestic violence homicides carry a lot of difficult issues. You'll see self-defense a lot. You will see accidents a lot. So a lot of times it's not an identity. It's not who committed the murder. It's did they have the required intent, which is an element of the murder charge. And so trials can get really hairy in that regard. And also the nature of the relationship comes into play a lot of the time in murder cases. So you're allowed to hear about all the good, the bad, and the ugly that surrounded the couple in the years leading up. And that is a big factor into the jury's determination of what sentence they should give a defendant.
Can children and family members of domestic violence homicide victims receive any state or federal assistance at all?
They can, depending again on what state you're in. You can file. A lot of times, the Attorney General's office will have a victims' compensation fund, so that's a way. That's a way for them to get some sort of money, but it has to typically go towards a bill. So I can't. It's worth calling the Attorney General's office if you're ever in that situation to find out what relief you may be entitled to, especially if you're a child of a woman that was killed, like we have in Miss Acevedo's case. And interestingly enough, I think family members and children sometimes make the best witnesses for prosecution because oftentimes they're the people that observed the relationship and can talk about what it was really like behind the scenes.
Absolutely. And, I know we're waiting on more details, but in cases like this, sentencing, how many years is the suspect potentially facing?
I imagine, if he's charged with murder, I imagine it's up to life in prison. And There's a lot of investigation that can be done. So I imagine they'll go through the cell phones and see their correspondence. They'll talk to family members of both Perez and Acevedo to really get an idea of what the relationship was like. But assuming that this was premeditated and that there was that they find he committed murder, he's facing up to life in prison.
And I have to ask, if you were his defense attorney, how would you argue this case?
That's tough to say because I haven't seen everything. I would really need to evaluate. I think some of the avenues, from my opinion, would be identity, because I haven't read that there was a clear eyewitness account of what happened yet. I think that there was a hearsay statement made through a phone call. But if that's not the route, then maybe there is a mental health evaluation that needs to be put into play, and maybe there needs to be a further investigation into why the relationship didn't work and things like that. And maybe there's a sudden passion defense. It's hard to say this early on.
Right. And this is a case that we will definitely be following. Anthony, thank you so much for coming on and joining me today.
Thanks for having me.
The family has created a GoFundMe page and hopes to use the funds to pay for funeral expenses. As of this recording, they've raised more than $8,900. For Law and Crime News, I'm Kennedi Walker.